attendees populate if they choose to. Just suffering a little bit of technical difficulty, so bear with us for a minute. Okay, the time is 5:02. The date is February 15th of 2024. I'd like to call the planning board meeting to order. As the recent amendments to open meeting law allows, the planning board will continue to hold meetings remotely. Adequate alternative access to the meeting is provided through the following link and phone number and meeting ID number. We will introduce planning board members and staff. Jane is at the top of the list this evening. My name is Rick Noon. I'm the chair. We have Beverly Bookin, Doug Cook, and we have Hank McCarl and Sean Henry. Staff members are Greg Catamatori, Eric Hinderly, and Catherine McNiff, our scribe. I'd also like to recognize Councilor Grow is in attendance this evening. And first item on the agenda this evening are A&Rs, site plan reviews, and preliminary subdivision plans. And first of which is a preliminary subdivision plan form B, Meridian Way, submitted by Robert and Patricia Callanan to be located at 22, 28, and 39 Pew Ave and 17 Pine Road, Assessors Map 219, lots 175, 130, 126, and 131.
And I apologize, I just realized I put up the agenda has since been revised just so that members of the public would be aware. We are in receipt of a letter from Seaside Legal Solutions from Joel Favazza requesting a withdrawal without prejudice of this application. So
Okay.
I don't believe there's any representation.
Joel is in the attendees list.
He is. I can allow him to speak, or he can raise his hand if he'd like to speak. Otherwise, you can act on the written request.
You there, Joel?
I am not seeing a hand, so you can act on the request that's been submitted in writing.
Okay. Jane, you want to take a crack at the withdrawal without prejudice?
Yes, for Meridian Way.
Yes.
Yes.
Yes, sorry, my dog just threw up on my feet. It was a little bit of a drama.
Too much information.
Yeah, sorry. Well, just whatever. I move that we accept the withdrawal without prejudice of the preliminary subdivision plan form B, Meridian Way, submitted by Robert and Patricia Callan to be located at 28, 22, and 39 Pew Avenue and 17 Pine Road.
I'll second the motion.
Thank you, Mr. McCarl. Roll call vote, please.
Member Noonan.
Yes.
Member McCarl.
Yes.
Member Bookin.
Yes.
Member Cook.
Yes.
Member Henry.
Yes.
And Member Renson.
Yes.
Thank you for that. Next on the agenda is site plan
Planning
review.
board meeting in session.
Sorry. Okay.
I think that was just Hank. Yep.
Yeah, understood. Site plan review application submitted by Beauport LLC for a 50-space parking lot to be located at 1 Gloucester Crossing Road, Assessors Map 262, Lot 13. This has been requested to continue to our May 16th regularly scheduled meeting, and we do have Attorney Ellison here as well. We'd like to speak to that.
Good evening, Mr. Chairman and board members. For the record, Deborah Ellison, Ellison Law Office, 63 Middle Street, Gloucester. The applicant's requesting that the site plan review be tabled until May 16th, 2024, to allow the applicant time to seek the removal of the off-site parking condition from the Beauport special permit. It was clear at the last meeting that the planning board members believe that is the preferred way to proceed. And I do agree that it makes sense to do that and to have the condition removed since the off-street parking has never been used. However, I'm not confident that that request will be approved. We would ask for the planning board support at the city council when that application is filed. I also just want to be clear that even if the modification is granted, the parking lot is not located, and the parking lot's not located on the Gloucester Crossing parking, that doesn't necessarily mean that the ALR will be built. As we discussed at the last meeting, there are some impediments to doing that, and these are two separate issues. But we would certainly like to seek a modification of the Beauport permit, and we ask your approval of our request to table this matter until May 6th. Thank you.
Thank you, Attorney Ellison. Jane?
You ready? Everyone ready?
Oh,
I move that we continue the site plan review for 1 Gloucester Crossing Road to May 16, 2024.
you have a
I'll
second?
second the motion.
Thank you, Mr. McCarroll. Roll call vote, please.
Member Noonan,
Yes.
member McCarl,
Yes,
member Bookin,
yes,
member Cook,
Yes.
member Henry,
Yes.
and member Remsen.
Yes.
Thank you very much.
Thank you, Attorney Ellison. Okay. So next on the agenda is a public hearing in accordance with the provisions of Mass General Law 40A, Section 5, and the Gloucester zoning ordinance, Section 1.11. The planning board will hold a remote public hearing to consider the following proposed zoning amendment. Amend Section 5.16, Village Development Overlay District, Section 5.16.12, affordable component as follows. In the first sentence following the phrase shall be restricted by deleting 40 for 45 years in 5.16.12A after low income by adding 60% AMI, and we may want to define that if it's not already defined. And in 5.16.12B, after moderate income by adding 80% AMI, and by deleting the paragraph following 5.16.12B and adding except as defined above, GZO Section 5.11, inclusionary housing requirement shall apply for any affordable component of the BDP, and by deleting Section 5.16.13, payment in lieu in its entirety. It's a tongue twister. So this is a council order that came from Councilor Grow. Gentleman is in attendance this evening if you want to give us your insights, and we will proceed with our public hearing.
Well, first off, thank you very much for having me. And I feel like I'm in the big leagues of planning and zoning right now. This is,
You kind of are.
yeah. I am.
Just, Jason, before you get into it, just name and address for the record, please.
Yeah, Jason Grow, 12 Marble Road, in Gloucester City Council. So this came out of my sitting in on a meeting where you were discussing a pre-application for a potential use to the Village Development Overlay District. And it occurred to me in looking through that aspect of the zoning ordinances, which I've never heard of before, and I don't think it's ever been used. There appeared to be some conflicts in the inclusionary housing, the inclusionary aspect of it, that seem to be in conflict with both the legislative intent in the beginning at 5.16.1 and also with our inclusionary zoning ordinance 511. And I think this, with also a couple of additional things that I've since looked at, is my intent was to clarify and to streamline so that the various parts of the ordinances are in alignment. The first aspect of it says in the first legislative intent that down about the fourth sentence, it says that proponent may increase density of housing by a set proportion in exchange for permanent protection of open space and for providing a mix of housing, including permanently affordable units. And then in later down lower, it says that there is a time limit of 45 years on that. Well, I'm not sure about your definition of permanent, but permanent seems to me that it doesn't have a time limit. So that was the first thing that needed to be taken care of. The second one was the application of the way that the 10% of the units as low income and the 10% of units as moderate income were allocated. And again, those definitions are in conflict with other parts of the ordinance where we talk about very low income as being below 60% AMI, where this says 50%, and low income as being 80% or less. And that is listed in definitions as moderate income under 516, but low income in 511. And again, I think it was, for me, it was more about getting other aspects of the inclusionary zoning to be in alignment with each other so that they match. The only thing that I didn't change, and I think is appropriate not to change, is that because of the density allowances for the applicants, this specifically had an increased amount of affordable units that might be allowed on completion of the permit. And I think that that's appropriate to keep in its division of 10% very low income and 10% low income. So that's the general thinking behind this. The deletion of 516.13, if we align this with 511, you don't need to have that redefined in 516.13. So you can, 516.13. So eliminating that doesn't eliminate the in lieu payment. It just puts it in alignment with 511, which defines the in lieu payment for all the rest of the inclusionary uses throughout the zoning amendments or zoning law. So that's that. And there were a couple of things that I found later on that I think that are relevant, and that is that in the definitions of 516.3.1 and 516.3.2, I think those definitions they again are in conflict with the inclusionary zoning ordinance, and so I think that it may be worth taking a moment to look at that and redefining that as the 60% and the 80% in low income and very low income. I don't know how to screenshot this, but I mean, I'm sure Greg can help out with that. But those are the main points of what I was trying to do. There may be, there's probably no other place except in the assisted living ordinance that has affordable defined in it. So that may be something for a future date, but I think the main goal was to get this in alignment so that everything was consistent throughout the ordinances. And that's what I got.
Thank you, Councilor Crowe. Greg, do you want to offer? Oh, go ahead, Jane.
No, go ahead, Greg.
I was just gonna say, Jason, you should have the ability to screen share if you just wanted to highlight those couple of comments that you just made.
Sure. I can do that if you like.
Go ahead.
I got to make sure there's nothing incriminating on the rest of my
Yeah, that's a
computer.
good
first.
idea.
Yeah.
You know, when you get elevated to panelist on the planning board, there are a lot of responsibilities.
There are. It's a lot of pressure.
I just don't
but-
want I just don't want any unnecessary things showing up on the screen there.
So
let me
While you're doing that, let me
yes.
throw something in, which is even makes the issue a little bit more confusing. I was helping write the Community Preservation Act housing section for Gloucester for the Community Preservation Plan. And the Community Preservation Act defines moderate income as 100% AMI and low income as below 80% AMI. And very low income is below 50%. There's no mention of 60%. So these are, we might have more homework to do, I think, because I think those definitions from the CPA statute are driven by the HUD definitions, and probably our definition should be also in alignment with the state definitions.
I would agree with that. I mean, I think that whatever we do, they should all be
The same.
the same. We should be
Yep,
working on the
they
same
should mean the same
definition,
thing.
same
And I think
playbook.
we all know what we want, which is, maybe 60 to 80 or 50, 80% AMI is the 10% and below 50% is another 10%, but we need to be correct in the vocabulary that we use to discuss it, which is
Right.
very
Let me
low,
sh-
low,
let me show
moderate, and-
the definitions as I've got them here, and we'll see if I've done this correctly. Yes, there we go. Is that what you're supposed to be looking at?
Yep.
Okay, so 5.16.3.1 says it's defined by the planning board. Low income shall mean earning less than 50% of the median income, and 5.16.3.2 says moderate income shall be anything more than 50% but less than 80%. And I think Jane's absolutely right. This should be in alignment for whatever we want to have in terms of the affordability component. That if it's 50%, great. If it's, I mean, we can do it 60%. There's nothing that I think prevents us from doing that, but we should be consistent with the language.
So let's ask Suzanne to get to the bottom of it, because I spent 20 minutes researching HUD and it's very difficult to find what the actual definition is, but unless Greg, immediately how to get there.
I would say that the definitions that we used in the current inclusionary housing ordinance requirements, because we just amended that 2 years ago, those were based on definitions pulled directly from those resources. So, this is from 24 years ago, 21 years ago. So I think there's probably some inaccuracies in what's, this is also a point though that the Council Grow raises. It's targeting a different AMI than our inclusionary ordinance. If you want to target 50%, that's fine. But if it should try to create consistency, it would be the 60, and I think the percentage is the thing that's probably most important in indicating, what
Right.
you're talking.
I don't think we should change the legislative intent of the VDOD, by the way, not
Right.
VDP. I just think we should use the right term, low income,
Sure.
moderate income,
Yep.
very low income. So I would say we should table this for 2 weeks and get that straight and then come back. We're being asked for a recommendation by P&D. Is that what it is?
That's
So
correct.
we
yeah.
are, the planning board is holding a public hearing as required for a zoning amendment. And certainly, if the intention is that we want to make sure that we get it right, it's going to take a little bit of time to either cross-reference or basically cut and paste to make sure that the correct definition is in there. I guess the only question would be, if the target is 50%, then we'll make sure that that's correctly identified and defined. Otherwise, if it's to create consistency with 511, then we only talk about two household incomes, and that's the 80% and the 60%.
So again, I don't know if my colleagues feel differently, but I don't think we should change the target. We should keep it whatever the legislative intent was. But we should change the terms: low, moderate, very low, blah, blah, income.
Other comments from board members?
Also, I agree with the 45-year, deleting the 45-year sunset clause, and et cetera. While everyone else is thinking of their other questions, I noticed Attorney Favazza is in the attendees. How would this affect the current application?
Well, we haven't opened the public hearing yet. So
I know, but if
hear from folks.
but as a procedural,
there's no application right now in front of you. So if this is enacted, this is what would
not
apply
affect.
to an application that's filed. Yeah.
Okay. Thank you.
John?
I was just going to say that while I agree with all the recommended changes and the homework that Jane is also recommending, I think in terms of recommending an actual change to the ordinance at this time, to be consistent with what we've said in the past, that we're going through the CPI process, that we'd sort of wait until we get towards the end of that to offer up what's likely going to be a relatively long list of corrections and adjustments in the ordinance that comes out of that process, and that all those things should be addressed sort of at that
Together.
point. Yeah. Not that I want to delay anything. I mean, I'd be ready to vote to say yes tonight, but I think to maintain consistency and to give credence to the comprehensive planning initiative effort there, that we'd probably be wise to wait to do any significant corrections or changes until we finish with that process.
Thank you, Sean. Beverly?
Is the CPI going to come out with recommendations for changing the actual text of the zoning code? I mean, by and large, is there going to be a list of that kind of thing?
I think
As a
there's both going to be policy recommendations, and then also there will be kind of an audit to a certain extent for consistency to begin with. Those will be some of the first implementation steps.
The reason I asked that is that we're also going to be doing the TOD planning, and presumably there'll be some changes out of that too. So I don't want to take something. I'm of mixed feelings. I just want to raise the issue that if we take a pass on this so that it adds to the other lists, that, you could argue then we shouldn't make changes to CPI. We should make changes when we get the TOD. So I just want to be consistent on how we deal with these proposals.
But I think the difference is that the TOD responding to 3A is we have a state mandated deadline for that, which we don't for any of the other zoning changes that we need to do respond to 3A to meet the state's required deadline, and anything that comes from the CPI doesn't have a deadline. I think it's going to be more of a either a wish list, sort of self-evident in the CPI, or as I think was the case with the Plan 2001 that resulted in the housing production plan that worked on those recommended zoning amendments, et cetera, down the road. I think that's the difference. The 3A, we have to respond to. The CPI, we let it run its course and act on it when it's finished.
Okay, I'm just raising the issue. I do know that my understanding of A is that however many units that we're required to demonstrate zoning, to provide through zoning, that only half of them have to be within 50, have to be within the TOD. Some of them can be in nodes elsewhere in the city, and it's not inconceivable that as part of achieving the densities needed to meet our state mandate, that we may go into this particular zoning provision and change it yet again. I'm just raising the issue about timing, and I don't have a problem with what's proposed, and I think it's good to make it consistent. It's just want the board to be really clear about how we think it's best to time these things. So I appreciate your input, Sean and Jane.
Thank you, Beverly. Any other comments from board members? Greg, Sean touched on sort of, obviously we don't have an application in front of us. And the planning board is the special permit granting authority. If a pre-application was to come forward, would it be within our purview to make the suggested changes to the underlying language as a condition of a special permit from the planning board?
No, I think you got to be fair to an applicant. What's on the books is what's on the books. So it's either amended and that's the rule of the land, or they'd operate if you were to just kind of suspend it and table it, which actually is probably the worst case scenario if it's just kind of hanging out there in an extended hearing process versus having some disposition on it. I mean, we can discuss further. I don't know if you want to take public comment first, and then we can talk about, where we go from here and what to consider. To Sean's point, I mean, there's any number of potential things that could come up in the next year that might come through a proposed zoning amendment. I mean, they can be filed either, in this case, by the council or the planning board, but there could also be some change that, somebody proposes that has very good intention and everybody supports, and then you're kind of in that same position that Beverly points out as to, what's the decision point? Are you going to hold off on everything versus, what you want to consider? And there's a hearing process associated with it. So it's something to consider, but this seems fairly discreet in terms of, trying to establish consistency. So it's up to the board how you want to proceed.
Understood. Thank you. Why don't we open to public comment? Oh, Beverly, before we do that, go ahead.
I was going to say, yes, let's take public comment because we do have people here who want to testify. We can always discuss this after the public hearing closes.
Thank you. So we are in a public hearing setting. We do have 4 attendees this evening. So I'd like to open the public comment period, and we'll take folks that are in favor of the City Council order to modify the underlying zoning. Simply raise your hand electronically. You'll be recognized to speak. And I just ask that you state your full name and address for the record and keep your comments to 3 minutes if possible. And if you're not familiar with raising your hand, if you use your mouse, you can find it in the middle of your screen on the bottom. Okay, seeing none in favor. Anybody that would be opposed to this recommendation? Attorney Favaza's got his hand raised.
Thank you. Are you able to hear me?
Yes.
Thanks so much. For the record, my name is Joel Favaza. I am an attorney at Seaside Legal Solutions. However, I'm speaking today, address of 123 Main Street. I'm not here speaking on behalf of any particular client. I'm speaking as a citizen. That address 28 Middle Street, to the degree that's required. I want to start off by saying, although I'm in opposition to the amendment as currently written, I'm not opposed to the concept of trying to figure out how to encourage affordable housing in Gloucester. I appreciate all the work that Councilor Grove puts in this effort. But as to why this particular amendment I would oppose, 3 quick points. One is I appreciate Member Henry in his comment. As you know, I've been before you on both some potentially wide-reaching and some very discrete potential zoning amendments. And one of the responses that this board has said is, well, we're in this comprehensive planning initiative process. We really should let that unfold before we go amending the zoning ordinance. And so I would expect and appreciate if the planning board continue to hold that mantra through to amendments such as the one before you. Secondly, I think it's important to look at the ordinance change in 511 that happened 2 years ago and get some data on, since then, how many affordable housing units have been created. Is that ordinance actually working? I can only speak anecdotally as a permitting attorney, but I can tell you that since that ordinance has passed, I have had multiple clients come into my office thinking of developing property into many units. I want to explain to them what's going to happen by way of the affordability requirement, which includes any fraction being rounded up. So if you hit a trigger where you have to provide 2.05 units, well, now it's 3, right? This is all the changes that happened 2 years ago. Or you have to pay this fee in lieu, and the calculation of the fee in lieu, Greg can correct me if I'm wrong, is close to $500,000 now. And that again goes away once you get over 9 units, et cetera. So I would be curious to see whether or not, as well-intentioned as they were, if those changes in 511 2 years ago have actually been producing affordable housing units for the city of Gloucester, because I've only seen them take propositions where someone comes in and says, I want to build 10 mid-grade units. And I talk to them about the affordable component, and they instead do 5 multi-million-dollar single-family units instead, which creates less housing, period, and creates more expensive units of the units that are being created from that process. So if it's working, then maybe that's credence for why it should be incorporated into the language of the VDP. But if it's not working, you might hesitate before bringing those terms into another part of the ordinance. The third part is the village overlay district and the village district special permit process. The intent was to create basically a strip of dense residential development along 133, where there's good access for vehicles, good access for utilities, water, sewer, gas, etc. Right? And as Greg pointed out, this thing has been on the books for 21 years. And in those 21 years, to my knowledge, not one property owner has been able to crunch the numbers and make the current requirements of the VDP process work for them. And now you would take this process that's already proven for 2 decades to be, again, despite best intentions back when it was written, too onerous for people to actually put into effect. You're going to make it more difficult to comply by adding additional requirements. You're going to make it more expensive for the property owner who might consider exercising or seeking a VDP permit. And again, if you haven't had anyone successfully permit this under the already onerous but less restrictive regulations you have, why, if we truly do want to work on this housing crisis, why would you take this and make it harder for someone to be able to exercise? Why would you not go, okay, the VDP isn't working, we need to make this easier for property owners because we need housing, and we've known for the last 20 years out along Essex Avenue is a great location for additional housing. So that's why I'm in opposition to the amendment as currently written. I totally applaud the sentiment. I totally applaud the desire to make it affordable for people to stay and live in Gloucester. I just don't think this particular amendment is hitting those targets. And I thank you so much for your time.
Okay. Thank you, Attorney Favazza. Anybody else like to speak under public comment? We have a hand raised. And again, I just ask you to state your full name and address for the record, please.
Yes, hi, I'm Saltanat Berzikeva. My address is 33 Middle Street in Gloucester. These are interesting zoning changes that you're proposing. My biggest concern is that a lot of the people in Gloucester, in the community, do not know that these zoning amendments are being proposed. So I think that I agree with Attorney Favazza's first point that this should be tied in with the comprehensive plan and with the zoning being all of these changes basically coming in to play with the public engagement part of the comprehensive planning. So I think more people should be aware what kind of things are happening, even with all the best intentions to make housing affordable. I think zoning is a very divisive issue right now. I think it will serve us all well if more people are aware of whatever kind of changes are happening to zoning. Thank you.
Thank you for that. Any other comments for or against? We'll get to you, Jason, in a minute. Okay, hearing none. So this is a public comment period. Do we want to go out of the close the public comment period for the moment? And then we can deliberate further.
Do I count as the public comment, or I don't actually deliberate with you guys, so.
Okay,
I'm not sure where I fit in the.
Well, you're technically a panelist, but if you got something to say, we'll grant that.
Well, I was just going to offer a rebuttal, which is, I think,
Yeah,
an
that's fine.
appropriate thing. And I would suggest on 2 fronts. First, to Member Henry's suggestion that we wait. I think, frankly, that there's very little likelihood that the outcome of the CPI is going to be to keep the inclusionary zoning conditions in our ordinances inconsistent with each other. So what I see in this especially is that it cleans up the language to create a consistent use of what we're talking about. And if they decide in the CPI process to modify the overall inclusionary zoning ordinance, then that would impact and clean up whatever is being amended, what I'm suggesting be amended now. So I don't think you're losing anything by fixing the inconsistencies that exist currently, because if they suggest that you change them later on, we make modifications, those modifications would apply accordingly. So I think you're risking the potential of having a proposal be put on the table that is then bound into inconsistent language with our ordinances. And I think that's what I I'd be wary about in terms of leaving it until the CPI is complete and done. The second suggestion or thought that I have is to Attorney Favaza's point. This doesn't actually make the inclusionary zoning more onerous. It just defines it, and in fact, it lessens if you go to the 60%, it lessens the impact on the applicant by 10% at 50%. It also, the biggest issue on here is for me is not only the consistency but losing the sunset clause. You don't want to create a situation where you have a lottery ticket at the end of 45 years and somebody gets all the equity that's ever built up into it. So I don't really see this as becoming more onerous to any applicant. It remains consistent with what we have and what we've decided to have for all the other kinds of developments and subdivisions and cluster developments and everything else. So I disagree that there's a disincentive there. I mean, it may be a disincentive to any developer. That's a policy issue about whether we should have inclusionary zoning, excuse me. But I don't think that my changes make it more onerous. In fact, it lessens the obligation of the applicant. So I'll leave those with you, and then I'll sit back quietly and
Thank you for your comments. Any other comments before we close well, yes, go ahead, Jane.
Yeah, I'd just like to say, echo Jason, that I completely agree with Sean and with Salta and with Joel that if we're making any substantive zoning changes, we need to have a larger process. It needs to be after the CPI is finished and we get our recommendations and everything. This seems to me like correcting a mistake in the village district overlay district, because the definition in that little ordinance is in disagreement with something later in the ordinance. And so we just need to get it corrected. I don't see this as substantive or changing the intent of the ordinance or anything else. We're just trying to fix a mistake.
Okay. Should we close the public comment period, Greg, and have further discussion?
Well, I guess a little direction if the intention is to also go back and take a look at the definition section to really create consistency internally within the ordinance as well, then you might want to keep that open, because if we come back with a red line version with other changes for a recommendation, we could have folks comment on that as well.
Okay.
So, and I'll leave it to you to further discuss and tell me what you'd like us to take a look at, because it would be a departure from what's been proposed, because the consistency to identify 60 and 80 is what Councilor Rose suggested. The intent of the ordinance has 10% at 80 and 10% at 50 or below. So that goes to Jane's comment about not trying to change the policy intent, but to create consistency. So perhaps the happy medium would be that you wouldn't actually be changing or identifying 60% AMI. You'd be clarifying that it's 50. So again, that's something. You tell me what approach you'd like to take.
Fair enough. So will the board, I think, Jane's point is well taken. And, again, dusting something off after 21 years. And the context that I have a sense of is that, we haven't seen a cluster development since Jack Clark put it on the books 20 something years ago. We've never seen an OSRD. We've done 2 clusters and 1 OSRD, and a village BDP shows up. And my feeling is that as space is not available for redevelopment, these tools that were contemplated years ago are now being applied, but in a very different setting. I mean, different time and space. So it is unfortunate that they didn't get reviewed during our zoning exercise, but I think the perspective of Jane saying that this is a fix, not changing the legislative intent, is something that we could probably discuss But I think, getting things aligned still needs a little bit of work, in my opinion. So anybody else has a comment along those lines? Beverly?
Well, first of all, as a point of order, do we have to close the hearing? Before
You
we
do
have
not
this
have to.
conversation?
No,
Pardon
you
me?
can keep it,
All right,
you can
we can
certainly
keep
keep it.
talking.
Yeah, you can
Okay.
keep it open
Okay.
and you probably should if there's going to be interim work
I
before.
think that's part of this
another meeting.
discussion.
Yeah.
Okay, that's fine.
Depending
I'm
on
just-
which way we go. Yeah.
I'm just raising issues. So I've got several thoughts. First of all, with regard to eliminating the 45 years, remind me, in our inclusionary zoning, are these units to be designated for their occupants in perpetuity, which is why we're removing the 45 years?
Yes.
Okay. And perpetuity, some zoning codes that designate these do them for like a set like 30 years or 35 years, because that's generally when the cost has been amortized. So we have to be clear if we mean that once these are designated for low income or very low income or whatever the definitions are, that it's in perpetuity. So dropping the 45 years makes some sense again for consistency. Secondly, though, if no one has ever built anything under the village provisions, and if we have a cluster plan provisions that essentially accomplish the same thing, isn't it possible that we just drop the village and look at the cluster development as a way of accomplishing this in projects that are a little off the, that are more, have more changes to them than would ordinarily go through the zoning code review. So I'm just asking whether we even want to keep this if no one's ever built under it.
But I think that comes under the heading of
The
major
CPI.
zoning review after the CPI. Yeah.
Okay.
Right. But-
Something to keep
but to
in
your po-
mind as a major change. I'm just suggesting we just might put them together and not have three different
Right.
things. But
But to your
Okay.
point, Beverly, the village overlay district allows multifamily housing. The OSRD and cluster development, I think, are limited to duplexes. So they are different in that sense.
okay, well, the other thing it's going to happen again, and I'm just raising issues. I'm not taking a position. I just want to think about it. Is that one of the issues is we don't have any multifamily zoning, and that should come out of the TOD.
So I think
Well,
you
we do
might-
have multifamily zoning in this particular ordinance. The village overlay does in fact allow for 4 families by right within the overlay district, or not by right, but it allows for 4 family development within the context of the village overlay. So we do have that.
But it's still not, we have no multifamily zoning by right.
Correct.
So,
you
the
might-
whole
yeah.
issue maybe rendered moot once the TOD is done. I'm just saying that we are kind of on the cusp of several changes. Now, if we want to make these changes because we agree they are not policy driven, they're consistency driven, they're correcting mistakes, we can do that. It's like a temporary fix. But I think that either out of the CPI, certainly out of the TOD planning, we may come up with some different zoning designations, and some of this may become moot. That's all I'm suggesting.
I think you might have missed a meeting where we discussed the cluster, the OSRD and this, and do it after the CPI, do a heavy zoning review of those 3 ordinances and figure out if
I
they're
think I
being
must have,
used.
I missed the
Yeah,
last meeting, but-
and whether they're in the right zones and,
Exactly,
an-
that's
an
sort of what
over-
I'm getting at.
right,
That's
an
what I'm getting at.
overhaul of those 3 ordinances, whether they conflict, whether we need them all, et cetera, but not now, not until after the
Right, that's my point.
after the
is that I think
TOD and
substantive
after the
changes.
CPI, right?
Right. So we may be doing really major changes. If we agree as a group that this is as a board, that the changes proposed by Mr. Groh are appropriate because they're minor, they're just bringing things in, they're correcting mistakes, I'll put it that way. And that's a placeholder, that's fine. probably isn't going to make any difference. If in 21 years there hasn't been one, in the next 2 years there probably will not be one. But nevertheless, it's taking a minor baby step on something that needs a whole lot more review in a bigger context. That's all I'm trying to get at.
Okay. Thank you for that, Beverly. So is the intent to take a breath and do some more realignment or getting language in place as far as lower income or the comments that Jane made earlier, so that we have consistency, or is it something that we want to act on this evening?
Oh, I think we definitely, I'm not prepared to vote yes on this at all. It's not correct.
Okay, fair enough.
I think we should give some study to this, but I think the consistency, as Councilor Groh has suggested, is important. We have no idea what the overall plan is going to result in, but it's likely to change a lot of these things. So I think as long as we get it in place, which we know that's straightforward, gets consistent with everything else, but it needs some study, it needs to be looked at carefully in order to get the consistency and get that taken care of. And then we worry about the overall changes as we get into the review of all this feedback that we're getting on the current planning, overall planning situation. I think get the consistency in there. It is.
Mr. Cook, thoughts?
Yeah, I mean, I totally get the consistency thing. I just, it's, I don't know who brought it up, but if we're gonna look at this, we might as well get this all right if we're making corrections in this kind of thing, and then call it that for the consistency issue, but wait till CPI to do major stuff.
Fair enough. So it looks like a continuance is in order.
So I'll just make a couple of comments, and so I will work on looking at the definitions in the 2 sections to make sure that we have consistency. I don't necessarily think that, I just want to make sure that to characterize, we definitely came across some recent experience with this ordinance where there was less than perfect clarity of some of the terms and intent. I don't think there was any kind of really mistakes being made versus just we have 20 years that have passed, and how, I mean, there could be change to federal definitions in that time period, or nuanced definitions as they've been updated in 511. To some of the testimony in terms of why there wasn't a mad rush to start filing village development overlay district permits. You also have to consider the configuration of the lots along Essex Avenue. Many of them didn't have any potential for additional development. But that doesn't discount the fact that we just saw a pre-application for a sizable piece of property, and this is the option that they're pursuing. So on the one hand, I just want to make sure that we're not saying the ordinance was broken. I mean, people had the option, but there were also many properties along Essex Ave that were already divided into smaller properties, single family or 2-family. And we've certainly seen a fair amount of development in that corridor because of access to sewer. So that has definitely been a significant change. There's been a number of conversions or tear down, rebuild because they had systems that were failing or challenged, and this created opportunity. So if that's the homework, I will work on that section and try to provide a red line in advance of the meeting on March 7th.
So Greg, just to totally clarify, 5.1.6.32, I don't know if you want to share screen, is defined, it says moderate income is defined as 50%, more than 50%, but less than 80% AMI. And so 5.6.12A should also say not 60%, but 50%, or at least 50% to 80%. But we, in the definition, we can change that to say low income, just to be in consistency with the other ordinances that we have in Gloucester and the state. But we're not changing the fact that 10% of housing would be required to be 50 to 80% AMI, and 10% of housing would be, just on another page, less than 50% AMI. We're not changing that. We're just
Right.
changing the vocabulary to get
Well,
it right.
that sounds like what you're recommending, because what Councilor Grow proposed was
understand.
actually, yeah, I
So
understand
that
what
is
you're
what I
saying.
am recommending. Okay.
Yes, okay. But we'll provide that draft in advance of that meeting, and then we can discuss it further.
It's probably
on
what
the-
Councilor Grove meant to recommend. honestly.
Speak for
To be
yourself,
honest,
Jason.
it's not. I
Oh,
actually
sorry,
meant
Jason.
I meant it to be consistent with the 511, which states 60 and 80%. It also states low income and very low income as opposed to low income and moderate, and those
Okay.
definitions are
Yeah.
inconsistent with each other.
I think
You'll have
that's
both
a bridge-
options to
a
consider.
bridge Too far, yeah. Okay.
That's up to you guys, but
Yeah.
the consistency factor was my my major goal here.
Okay.
So I guess we need a motion to continue this public hearing.
I move that we continue the public hearing to amend section 5.16 Village Development Overlay District to what meeting?
March 7th.
March 7th, 2024.
We have a
I'll
motion.
second the motion.
Thank you, Mr. McCarl. We have a motion and a second. We need a roll call vote, please.
Member Noonan,
Yes.
Member McCarl,
Yes,
Member Bookin,
Yes,
Member Cook,
Yes,
Member Henry,
Yes.
and Member Remsen.
Yes.
Okay, thank you. That's why I stretch out before meetings, Jason.
Makes sense. Absolutely.
Right.
thank you.
All right, just need an agenda.
When you're using the track.
Okay, under other business, election of chair and vice chair of the planning board. We've been putting this administrative off a little bit, so we need to get it squared away. I know we talked about it in our last discussion. So nominations.
I nominate Rick as chair.
We have a second.
I'll second that.
So roll call vote, please.
Member Noonan,
Yes.
Member McCarl,
Yes,
Member Bookin,
yes,
Member Cook,
yes,
Member Henry,
Yes.
and Member Remsen.
Yes.
For chairman.
Nominations for vice chair.
I'd like to nominate Jane Remsen for vice chair of the board.
We have a
I'll second
motion.
that.
Okay.
I'll
motion from
second.
Mr. McCarl.
Oh.
And
I'll second it.
Okay, we'll give it to Beverly, even though Sean spoke first.
Okay, sorry, Sean, you can have it if you want. I don't care.
Nobody's
Catherine
gonna
can
get
decide.
points tonight. So we do have a motion and a second. We need a roll call vote, please.
Member Noonan,
Yes.
Member McCarl,
Yes,
Member Bookin,
Yes,
Member Cook,
yes.
Member Henry,
Yes.
and Member Remsen.
Yes. Thank you.
do we have a secretary? Is there another office that we're,
No other office.
those are the only two? Okay, fine.
And just to take a minute to thank Hank McCarl for his long service as vice chair and on the planning board. We look forward to plenty of senior guidance as we work our way through the next 2 years of heavy lifting. So
Senior
thank-
guidance is still available as long as I'm on the board. Thank you.
That's right. Thank you very much, Hank, for your service. And we'll always look to you during baseball season to make motions to adjourn, just so you know. We do have one set of minutes to review, thankfully, Catherine,
Two.
for
Two.
February, so
Here too.
February 1st, two, I'm sorry, thanks, I stopped reading. So let's look at, why don't we look at August of 2020?
All right.
Dusted that one off. Okay. Nobody was absent.
I like how you discussed lengthy presentation.
Mhm.
I actually looked at the video today. That was a 3+ hour meeting.
Yeah, no kidding.
Right.
As is typical for Judy. Regarding 467 Washington Street. Catherine, did you watch the video? Yeah, so at some point I brought up whether or not there was a conflict of interest with the owner being the Gloucester,
Oh, yeah.
whatever he was. And was it during this meeting or not? Or if you didn't, I can't hear you because you're muted.
Yes, and it is noted in there.
Oh, it is?
Yeah, let's see.
Oh, right there. It should be noted a bit
Yep.
earlier in the evening. Okay. Yeah, but okay. So the Board of Ethics found no conflict. Okay. Okay. Yeah, I just want to make sure that was mentioned. I missed it. Thank you. I move that we approve the August 6, 2020 minutes.
A second, please.
Second,
Thank you. Roll call vote, please.
Member Noonan,
Yes.
member McCarl,
Yes.
member Bookin,
yes.
member Cook,
Yes.
member Henry,
Yes.
member Remsen.
Yes.
Right. All right, back into current history, February 1st.
So right there, the second sentence says so far compliance has been met. Because because I thought compliance has to be by the end of the year.
No, there were
For the
interim
action.
steps.
That had to be done, but by
Yeah,
now.
so we had to file the action
Okay.
plan.
Okay, okay, got it. Never mind.
Short one.
Okay, I move that we approve the February 1, 2024 minutes.
Second, please.
I'll second it.
Thank you, Hank. Roll call vote.
Member Noonan,
Yes.
member McCarl,
Yes.
member Bookin,
Abstain, I was not there.
member Cook,
Yes.
member Henry,
Yes.
and member Remsen.
Yes.
Terrific. I think that wraps it up. So no matters unreasonably.
Just announcing that there'll be a special meeting next Tuesday night at 5 p.m. And it will be a presentation from the consultant hired to assist with the 3A technical, or the 3A zoning. RKG, that'll be Eric Halverson that will be making that presentation, and we'll start at 5. And we will be meeting jointly with the Planning and Development Standing Committee, all via a remote meeting.
And again, public meeting, not a public hearing.
Yes. Yep.
Beverly?
Any decision made when we are going to meet back in person? I know we've had this conversation for about 6 weeks.
So there's still trying, I don't think all of the facilities are set up yet.
Okay.
But that is something that we could certainly consider.
Okay, it's coming, I gather. Don't we have
Yes.
a state mandate? Is
No,
it
you have the
May or
ability
something?
to meet this way as well for quite some time.
Okay,
But you know,
that's fine.
the hope is that all the meetings will be hybrid.
Okay, thank you. I just
Yep.
wanted an update. Thank you.
And Bev, we also have a training meeting at the end of March, I want to say, if you got that invitation.
I don't think so. I was away and so I may have
Okay.
missed it.
Okay. Anyway,
Greg, do you just want to send it to me and I'll get it on my calendar?
That's, I don't even know about it.
Oh,
I think it's,
Weird,
I think it's
okay.
for, I think it's for board members, so I'll check. I think it's being run through the solicitor's office in IT, but I can make sure that, if that's gone out, to make sure that it's gone to all members.
is
I
the
think it's
training session one on
mid-March.
ethics? Is it on
No,
method?
no, I think
ethics and
it's
that kind of-
on the hybrid setting.
Oh, all right, that's
What,
fine.
what push,
All right.
what buttons to push. Which became an
Okay,
issue
thank you.
yesterday.
If someone could just, I'll get it on my calendar. Thank you.
Very good. Mr. McCarl,
I'd like to offer a motion to adjourn, Mr. Chairman.
thank you. Need a
I'll
second.
second.
please. Thank you, Mr. Cook. Roll call vote, please.
Member Noonan,
Yes.
Member McCarl,
Yes.
Member Bookin,
Booking. Yes.
Member Cook.
Yes.
No, I already did Cook. Did I do Cook? No, I didn't.
No,
Sorry.
yes.
Boy, am I tired.
Mhm.
Member Henry
Yes.
and Member Remsen.
Yes.
Okay.
All right. See you guys Tuesday.
We'll see you next Tuesday.
Yeah, I'm sorry to
folks.
miss it, but
Good night, all.
you're gonna make it available.
It will be recorded. Yep.
Available. Yeah, that'll be great. Thank
Okay.
you.
Bye.
Good night.
Bye
Bye,
now.
folks. Bye.
Have a good President's Day.